was accused of being a female jail employee just appeared in court.
And while he was in foster care, that he was sexually abused by one of his relatives.
And I'm going to let y'all know how bogus they are. They are bogus.
A man accused of stabbing a woman and stuffing her in a container had an outburst in court, flipping off the judge in anger over his bond being set at $750,000. Meanwhile, the victim is fortunate to be alive. The case has made headlines, with Edmund Guyger Sr. facing charges of attempted murder. Despite pleading not guilty, he had already confessed to the crimes to police. According to the police, the discovery was made at Guyger's home at 97th and Lorraine after a woman reported that he had shown her photos of the victim tied up in the basement. During their second search of the house, officers heard what sounded like a heavy object and cries for help. That's when they found the woman inside a 3x3 plastic container, motionless, with the lid sealed. Miraculously, she was still alive. She was rushed to a hospital. Edmund Guyger was arrested, charged, and initially held on a $500,000 bond. However, he pleaded not guilty and expressed frustration when the judge increased his bond amount.
$750,000?
That's correct, and there's also a probation hold.
Well, okay, can y'all lift the hold and at least let me try to post bond? I don't think nobody in the courtroom got $750,000.
You'll have to speak with the judge assigned to this case, which is Judge Holly Gill.
I'm about to fire. I need a new judge. I need a site judge and everything. That's crazy. Why y'all open my bond?
When the judge did not respond to him, Edmund Guyger angrily flipped her off. Regarding the survivor, it's reported that she was on a ventilator. This next story seems more like a horror movie than a real event in a local community. What began as a tip involving kidnapping, starvation, and beatings quickly turned into a rescue mission. 62-year-old Freda Underwood had her chance to speak in a Clermont County courtroom. Freda sat in court alongside the Union Township Clermont County police officers who rescued her from Ellis and his partner, Colleen Haynes. The couple had initially offered to care for Freda, who was disabled.
Because she knows, I know, this court knows, that this is one nightmare that Miss Underwood's never going to wake up.
Tim Ellis pleaded guilty to kidnapping, assault, and stealing Freda's social security checks. During today's sentencing hearing, evidence included a photo showing what Freda looked like when police found her. She weighed only 92 pounds, surviving on just one sandwich a day. Other photos revealed her chemically hands, caused by being forced to clean them with bleach without any gloves.
I think that he really deserves to be punished for the way he treated me.
The judge agreed.
It is suggested that if the defendants were left to their own devices and without police intervention, the victim would either be in a continued state of imprisonment today or possibly even deceased.
Freda quietly celebrated when the judge sentenced Ellis to 21.5 years in prison.
They threatened me that if I said anything to the police, that they would find me and kill me.
And she wasn't able to use the phone, wasn't able to leave the apartment, wasn't able to communicate with other people in the apartment complex. Obviously, that was a systematic purpose to maintain control over her and to take money from her.
Now, Freda lives in a residence with other seniors, where she looks forward to arts and crafts and dancing. Derek Brown, found guilty of assaulting a woman in River West Park, caused a major commotion in a Milwaukee courtroom during his sentencing. When allowed to address the court, Brown went on a rant, turning to face the camera directly while proclaiming that he was the real victim in the case. He entered the courtroom with a smirk, showing no remorse for the unthinkable crime he committed against the woman in the park on Bremen Street.
And I'm going to let y'all know how bogus they are. They are bogus. They are heinously convicting me and sentencing me, and I'm going to get out of here, and I'm going to speak to the world. You hear me?
We're not going on with this argument.
Trayvon Martin, Dante Hamilton, I am a victim. I am going to be victorious.
Turn the microphone off.
Turn the microphone.
This was Derek Brown's sentencing hearing following his conviction for an attack that took place. His DNA had been linked to the crime. The victim shared a photo on social media from the hospital, where she was being treated for her injuries. According to the court, Brown approached her with a gun pressed against her back while she was walking along Bremen Street. He forced her into a nearby park and threatened to rape her, but instead, he began brutally beating her. Her screams for help were heard by someone nearby, prompting Brown to flee the scene. Despite this, Brown showed no remorse. As he was escorted out of the courtroom, he smiled at the camera and repeatedly shouted, "God has my back." The judge sentenced Derek Brown to more than 44 years in prison, followed by 22 years of extended supervision. During the hearing, the judge also read a statement from the victim, who shared that she continues to suffer from the physical injuries she endured during the attack, and is still dealing with the mental torment caused by the incident. The victim in the serial rapist trial shared the terrifying details of her assault, but it was what she revealed happened afterward that left the entire courtroom in shock. She stated that right after the attack, Ikeie Smith spent nearly an hour talking to her about religion. This unexpected testimony was given during a hearing in Dearborn Heights. The victim told the court that she had been raped once before, years earlier. On the night Smith allegedly entered her home, she was determined to protect herself and her child, who was sleeping in the next room. Instead of fighting back physically, she chose to rely on the power of prayer. Now, back in court in Dearborn Heights, Ikeie Smith faces accusations of raping multiple women over several years. However, the focus was on a case from 2013. On the witness stand, the woman described how she was jolted awake from her sleep.
I rolled over in bed and I saw a flashlight in the doorway.
She testified that a man jumped into her bed while her child was in the next room.
"I'll hurt her, I'll hurt you." He held a knife to my neck.
The woman testified that she told her attacker she had been raped before.
I was trying to make him see me as a person, to have sympathy for me.
Smith is accused of briefly backing off.
"I still have a desire, I still want to do this. I want you to feel how excited I am," and he took my hand and made me touch him.
The court listened as she explained that she began praying out loud, not for herself, but for the man in her room.
He got off the bed and walked around in circles and he said, "Why did I pick this house? Why did I pick this house?" And I said to him, I said, "Maybe it's because God wanted you to hear a message."
For over 45 minutes, she pleaded with him. Eventually, he began to share details about his childhood and how his mother was a drug addict.
Out of that, he ended up in foster care, and while he was in foster care, that he was sexually abused by one of his relatives, and so that he blamed his mother.
The victim provided some chilling testimony, stating that Smith told her the devil had driven him to enter her home and attack her, as well as the other women. Prosecutors revealed that Smith eventually left without further harming the woman in Dearborn Heights back in December 2013. He now faces charges of sexual assault, home invasion, and torture, and the judge has decided to move forward with the trial. It was clearly a harrowing ordeal for the woman, having to deal with him for 45 minutes. In court, Smith was seen staring straight ahead, occasionally glancing down as he flipped through the pages of a Bible. He left the courtroom with the Bible in hand, though prosecutors suggest it's too late to believe the woman had any meaningful impact on his life. As soon as the court session started, it was obvious that Darnell Booth was upset. The moment he heard the charges against him, he broke down.
Well, versus Darnell K. Booth, one charge of rape. Okay, Mr. Booth, call.
Prosecutors claim that Booth first met the girl while working as her Uber driver. After that, he started sending her messages on social media. They allege he continued to pursue her, picked her up again a few days later, and then raped her.
He pulled into a parking lot. At that point, he turned and told her to take off her pants.
But pay attention to his response to the next accusation.
At that point, he leaned over from the driver's seat and slapped her in the face on 2 occasions.
Booth has an 8-page criminal record, including a previous sexual assault allegation, though he was never arrested for it. This time, however, investigators discovered his DNA on the girl's shirt. Still, his lawyer argues that the girl's story might not be consistent.
I have received a police report, and I've listened to the statement of probable cause, and I would suggest that there are far more questions than answers.
It's also important to note that Booth was not working as a driver at the time of the alleged rape. He had already been banned from driving and has stated that any of his prior criminal history is over 7 years old. A judge handed down a sentence for a man convicted of raping women he met online. Derry Robinson, now a convicted rapist, was sentenced to 125 years in prison. It's a lengthy sentence, and the judge described it as one of the most horrific cases she has ever handled. Robinson was found guilty of raping 3 vulnerable women whom the judge and prosecutors say he specifically targeted. The case began to unravel after he raped a woman he had met on a website. According to court records, Robinson arranged to meet her for a date, but instead assaulted her and stole her cell phone. She managed to run into a police squad who took her to the hospital and started the investigation. It didn't take long for investigators to connect this case to similar reports linked back to the same website. They also traced IP addresses, which led them to Robinson. In court, one of the victim's mothers gave an emotional impact statement.
You said you were mad at the world. I don't understand that. What matters is how your selfish actions have affected them and their families. I've lost my little girl. She can't even leave the house.
The mother also wanted to make it clear to the community that it doesn't matter how these victims came into contact with Robinson, even if it was through a website. What matters is that he violated them and took their cell phones so they couldn't call 911 for help. She emphasized that such actions deserve punishment. A jury found Rashid Powell guilty of multiple crimes, including several counts of first-degree aggravated sexual assault and second-degree sexual assault, as well as burglary, robbery, and weapons charges.
It is monsters like you who taint the world and make it unfair and so dark. You've robbed me of my innocence and my youth. You've made me an antisocial person. And today I can look at you without being afraid. You brought pain so deep in my life that I never knew one can feel. You deserve an execution, the death penalty, if it were my choice. I hope you do not ever have the option of seeing daylight again. You deserve to get a sentencing that is so hurtful to you that I hope it makes you cry in front of us. I want to see you cry. You deserve to feel how you made me feel, them feel, and the ones who are so fearful of coming today.
I feel sorry for you if you saying I'm the one, you don't even know who the person was, don't even know what the person looked like. All these other people pick different people out and turn around and pick me out. It's just like it was all set up from the beginning. I'm not no serial sexual person as the person described me as.
Mr. Powell, you are indeed a serial rapist. You prey on the vulnerable. At this point in my career, Mr. Powell, it is difficult to shock the conscience of the court. But you have managed to do so. Your crime spree ends now.
He was sentenced to 148 years in prison. James Daniel III received a sentence so long that he will likely spend the rest of his life in prison unless an appeal is granted. A Cuyahoga County judge sentenced him to 144 years to life, a severe sentence that drew no visible reaction from this violent offender.
Mr. Daniel does not waste much time between being released from prison and committing another serious offense. He will not be given that opportunity to do that again.
Cuyahoga County Judge David Mattia showed no leniency in his sentencing of the early morning rapist. He handed down a punishment so severe that James Daniel III will never be released in his lifetime, a decision that prosecutors had hoped for and applauded.
This defendant has violently assaulted 5 separate women. He has dramatically altered the course of their lives.
3 of the 5 women involved in the case are rape victims, while the other 2 are victims of Daniel's burglaries. The crimes covered in today's sentencing took place in 2000 and 2014. The most notorious incident was caught on surveillance video, showing Daniel attacking a runner on Cleveland's near West Side in the early morning hours, an attack that occurred just days after he raped another woman during the early morning hours.
Daniel did in fact plead to those remaining charges that were left in the indictment. He did in essence, take responsibility for those charges.
Daniel remained silent during his sentencing. His attorney explained to the court that this was because he plans to appeal his trial case. Throughout the hour-and-a-half hearing, Daniel showed no emotion and made little eye contact with anyone in the courtroom. The prosecutor mentioned that any chance of an appeal is improbable since life sentences are mandatory in Ohio. The judge closed the sentencing by thanking the jail custodian who had to clean Daniel's cell. R. Kelly has been sentenced to 30 years in prison. The 55-year-old disgraced singer received his sentence after being convicted of racketeering and sex trafficking. Dressed in dark glasses and a khaki shirt, the judge asked Kelly if he wished to make a statement, but he declined. In delivering the sentence, the judge emphasized the need to protect the public from such behavior. Several victims also spoke out about the sentencing.
I never thought that I would be here to see him be held accountable. I stand here very proud of my judicial system, very proud of my fellow survivors, and very pleased with the outcome. 30 years did he do this, and 30 years is what he got.
Katie, does this send a message?
Yes, it does. It sends a message to other survivors that, you know, this is a day and time that we're being heard and believed.
The prosecution team stated that R. Kelly had managed to avoid punishment for decades.
R. Kelly is a predator, and as a result of our prosecution, he'll serve a long jail sentence for his crimes.
His attorney described Kelly's mood after hearing the sentencing as subdued and resigned.
Obviously, he's devastated. 30 years in prison is like a life sentence for him.
Attorney Gloria Allred represents several of the victims in the case.
While he is in custody, he will not be able to continue to sexually victimize any other underage girls.
If Kelly serves his full sentence, he won't be released until he is 85 years old, and today's sentencing isn't the end of his legal troubles. Malcolm Analicia, the 21-year-old suspect, faces a long list of charges as he enters the courtroom. Michael Sykes is charged with kidnapping, criminal sexual conduct, armed robbery, and multiple weapons offenses, among others. He is accused of sexually assaulting 5 different women, with 3 of the attacks occurring back in March. During his preliminary hearing, 2 of the women testified, stating that he forced them to perform sexual acts at gunpoint. They managed to escape by promising not to report the crime, but they eventually did. Malcolm Analicia was sentenced to 46 years in prison, with all but 15 years suspended. Rondell Harris, a Youngstown man already in prison, was sentenced after pleading guilty to charges of raping and kidnapping a Mahoning County Jail employee. At the same time, he was imprisoned for a vandalism charge. During the court proceedings, Harris went on a profanity-laced rant while entering his guilty plea.
He was accused of being a female jail employee just appeared in court. It was supposed to be the start of his trial.
A Youngstown man already in prison will spend at least the next 26 years behind bars after appearing in court this morning. Rondell Harris was accused of a Mahoning County Jail employee while he was being incarcerated on a vandalism charge. In court this morning, Harris went on a profanity-laced rant while pleading guilty to and kidnapping the victim back in March of last year. In the end, Judge Anthony D'Appolito sentenced Harris and classified him as a Tier 3 sex offender, meaning he'll have to register every 90 days for the rest of his life.
Judge Anthony D'Appolito sentenced him to serve at least 26 years behind bars. He classified him as a Tier 3 sex offender, requiring Harris to register every 90 days for the rest of his life. Shawn Pickett was sentenced to life in prison without the possibility of parole for the murder of his mother, Susan Pickett, and their family dog, Chico. The court focused on the horrific nature of the crime, including Pickett's claims of hearing evil voices, which played a significant role in the prosecution's presentation of the case.
I won't be giving a terribly long opening statement in this case because the facts of it are really quite straightforward. You'll learn that at approximately 3:37 p.m. on Monday, May 10th of 2021, the Iowa County Sheriff's Office received a 911 call from then 21-year-old Shawn Pickett, reporting that he had come home to his residence at 602 William Street in Avoca to find his 54-year-old mother, Susan, and his pit bull dog, Chico, dead. That phone call kicked off an investigation that has culminated in Mr. Pickett standing trial before you today on charges of first-degree intentional homicide and intentional mistreatment of an animal causing death. In support of those charges, you'll first hear from Avoca Police Chief Dan Carey, who was the initial law enforcement officer on scene after the 911 call was received. He'll tell you how he made contact with Mr. Pickett while Mr. Pickett was still on the phone with the dispatcher. When Chief Carey asked him what happened, he'll explain how Mr. Pickett stated that his mom and his dog were dead in the residence. Chief Carey will tell you of his immediate observations of blood on the clothing, the pants, the shirt, and the shoes of Mr. Pickett. He'll explain how he and another responding officer, Chief Bill Schramm of the Muscoda Police Department, first made entry into the home, working their way through the main living areas, down the hallway to the last bedroom on the left. He'll relay how when the officers opened that door, they located the bodies of Susan Pickett and Chico the pit bull lying dead in a pool of dried blood on the floor. Chief Carey will note how Mr. Pickett mentioned him that he believed his mother's boyfriend, Ernest Wheeler, was responsible for their deaths. Treating the matter as a homicide, Chief Carey will tell you how additional law enforcement resources were called to aid in securing and further investigating the scene. I expect you'll hear testimony from Ernest Wheeler, Susan Pickett's boyfriend. He'll tell you how he and Susan had been together for roughly 5 years before she was killed, including living at their residence together in Avoca. You'll learn how Susan and Mr. Wheeler moved to Iowa in January, again leaving Shawn behind by himself in Avoca. And he'll tell you, confirming again, that he brought Susan back to Avoca about a month prior to her death to finish packing up their home, which upset Shawn, and as did Shawn's recent discovery that Mr. Wheeler was previously placed on the sex offender registry. Mr. Wheeler returned to Des Moines the night he dropped Susan off, and he last spoke with her on May 6th. He was awaiting Susan's call to return to Avoca to pick up her and the remainder of their belongings to return to Iowa. But the call Mr. Wheeler received instead was a call from Chief Carey informing him that Susan was dead. On the expert side of things, you'll hear from Dr. Robert Corliss, the forensic pathologist who performed the autopsy on Susan Pickett's body. He'll explain to you in detail how the serious blunt force injuries to Susan Pickett's head were the cause of her death, and he'll describe the multiple also sustained by Susan, leading him to conclude that her death was indeed a homicide. Some of those photos may again be difficult to view, but they're important in understanding of the extreme manner and force that was used to extinguish Ms. Pickett's life. Although not a veterinarian, Dr. Corliss also conducted a limited examination of Chico's body, and he'll be able to provide some brief testimony about what he observed on Chico as well. You'll see, however, that overall, this really isn't a complicated CSI-type forensic case, because there's no real dispute about who killed Susan Pickett and Chico. On that point, you'll hear from Michael Mansavage, one of the investigating special agents from DCI who interviewed Shawn Pickett on the evening of May 10th. He'll tell you how Shawn reported being upset about being stranded by his mom and Mr. Wheeler when they went to Iowa, leaving him home alone at the home in Avoca with no food. When they returned to the house about a month prior, you'll hear how Shawn got into an argument with Mr. Wheeler, who then returned to Iowa. He will relay how Shawn told his mom about Mr. Wheeler's offender past and how she was surprised by that and didn't want to believe it. Nor will you see any significant injuries on Shawn's body to indicate that he had himself been attacked or in any physical danger from Susan. To the contrary, I'll encourage you to listen to that video where Shawn will tell you only that Susan and Mr. Wheeler had played mind games with him, but he'll state that his mom didn't fight him. She wasn't saying anything to him while he killed her, and that even Chico didn't try to defend her. Ladies and gentlemen, that's the gist of the state's case. And at the close of evidence, you'll be instructed by the judge on the law applicable to it. And you'll be asked to employ your reason and your common sense in weighing the credibility of the witnesses and the stories that you've heard from them. Based on that testimony and the evidence you've seen with your own eyes, again, it's not a complicated story. And I think you'll readily see how the physical facts presented will line up with Mr. Pickett's confession to show beyond any reasonable doubt that he intentionally killed both his mother and his dog. And it's for that reason that at the close of evidence, I will ask you to find him guilty of both counts. Thank you.
Jerry Erickson. And then when she did discover them, she went over and he said, yeah, they left me here and, I'm just here with Chico. He had a big 50-pound bag of dog food for Chico and that was, and he did what he could to get food. I know it seems shocking, but the facts will show that they were in this extreme impoverished situation in the midst of, the town of Avoca, living in town. And then a few days later, after Ms. Nundorf discovered Shawn was there, Susan and Ernie return. Ernie stays for a few hours before he packed up things and returned to Iowa with the confrontation about this requirement of registration. And there's an angry confrontation and it prompted Ernie to leave. And then 2 weeks where it was just Shawn and Susan left there. And they were left stranded in a desert of possibilities. In other words, they were left to fall back on one another's weaknesses, addictions, alcoholism, failures, alienation, to just fester and be frustrated and fear. And this was the context. And you will hear from these witnesses, these lay witnesses as the state describes them. And they will describe things that, for lack of a better word, seem almost nullities, that maybe they're significant and maybe they're meaningless. Mr. Gilbertson, who by all accounts seems to be a rather passing acquaintance for reasons unexplained, just happens to show up that day and talks to Shawn and makes what he later describes as observations of Shawn acting odd, but we don't have any context for that. Just Shawn standing at the door talking to him, and Mr. Gilbertson invites him out and smoke, and he didn't wanna. And so Mr. Gilbertson makes conclusions from that. He makes conclusions that the dog isn't barking. Miss Nundorf, she'll relate, that morning she was going back and she saw Mr. Pickett sitting in his garage at midnight. And this garage will be shown to be full of things, none of which were packing boxes or anything like that. There certainly was many material objects left, not suggesting an imminent flight to the state of Iowa by Susan. This is the context that the facts will show. I mean, right now, as we stand here, there's no evidence that's been presented. We are just telling you what we think the evidence will be. This is a blank slate before you to be transcribed, written on by statements of strangers to you. Some will be presented to you as experts. Some will tell you what they saw. Some will tell you what they heard. But one will tell you what happened, and that would be Mr. Pickett. And what happened was that Mr. Pickett acted in self-defense upon discovering his mother stabbing the dog, that when he confronted her with it, she turned upon him and was the object of her aggression. And you'll see it's a very small space. And you'll hear evidence that he had acted in self-defense upon this confrontation. But you will hear further, as the state said, that afterward you will hear statements Shawn had made. And we feel the facts will show that an overwrought, insomnia-addled mind from whence Shawn's wit has to slog through this swamp he's in of shock and stress from what he's just experienced. That, given all of these factors, this isolation that he's experienced, in those 2 weeks when his mom came back, for example, it had gotten so bad, the evidence will show that he'd gone to this little bit of woods by the cemetery there, the city cemetery there in Avoca, and he had taken a duffel bag of clothes and some food and hoisted up this little tent with this tarpaulin and was just living out there, and it was still cold. Even on May 10th, it was a cold May in 2021, and he was coming in and out. He was going back and forth, but a lot of the time he was spending in this little bitty tent with obviously no services. That's how bad it had gotten for him. And so coming from that, upon being confronted by the officers, being taken into protective custody, upon him calling 911, and them taking his clothes for evidence and him being just wrapped in a blanket, that when he talks to them, he offers this fervid, feverish, false confession, much of it nonsensical, referring to how they'd been playing mind games.
I went to the next room.
Okay. And when you're in the next room, the door was closed?
Yes.
So you heard something behind the door?
Yes, it sounded like a commotion, yes.
And then you opened the door?
Yes.
And when you opened the door, what did you see?
My mom was still Chico.
And was he on his back, or was he on... could you tell?
Kinda. I mean, it happened. He was on his back or his side. Yes.
Okay, so you see her stab Chico, and what'd you do?
I pretty much kind of like yelled like, "Hey," or like, "What are you doing?" Pretty much, or almost like something like that. Almost indistinctively, it's just natural instinct.
Okay. And when you yelled, "Hey, what are you doing?" then what happened?
She looked surprised, and she turned around and she came at me with the knife.
Okay, and were you all the way in the room at this time?
Yes.
And was the door closed behind you?
Yes. I didn't like walk in. I opened the door and then I kind of like fast walked into the room. So almost kind of like ran in, but I didn't.
Okay. And then you ran in and she came at you with a knife, and then what happened?
We wrestled over control of the knife. We wrestled over control of the knife, and which is surprising because she was a small woman, but I was very malnourished at the same time. She was very strong. We wrestled and fought over control of the knife, and instinctively and naturally, I got a hold of it once or twice, and we were still wrestling, and I just naturally stabbed her 2 times, I believe.
Okay.
To get her to stop attacking me, because she would not stop attacking me.
And when you twice, did she then stop attacking?
No, she didn't even respond to it. She didn't respond.
But you had gotten the knife away from her?
Somewhat, yes.
Okay, so
she was still trying to grab it when I got somewhat control of it.
She was still trying to grab the knife?
Yes, from me.
And that was when you stabbed her?
Yes.
And then subsequent to that, did you just leave the room then, or what happened?
No, we continued fighting, almost kind of like wrestling, and we kind of tripped because the room was very small. She kind of like tripped over the bed a little bit, and the knife fell, and she fell for a second, and I seen that as my opportunity to go and get help, and I went towards the door.
When you say you tripped over the bed, this wasn't a bed that was on a frame, was it? It was just a mattress laying on the floor?
It was just that big mattress, yes.
And it wasn't like a mattress on top of a box spring. It was just the mattress laying on the floor?
Yes.
Okay. So you tripped over that, and you both tripped over it?
Yeah, pretty much. I kind of caught myself more than she did, so.
Okay, and so you said that you took that as your opportunity to leave?
Yes.
Why were you going to leave?
Call for get help. Call the cops to get help.
Okay, but did you leave then?
I got to the door, and as I got to the door, she was up and coming at me with the knife again.
So she had recovered the
Yes.
Had it fallen to the floor?
It had fallen to the floor when we tripped, yes.
Okay, so you saw her coming at you with the knife again.
Yes.
And then what did you do?
Well, the door's right there, and you got this, the dresser was right there where the machete was on. Her boyfriend likes swords and all that stuff, so the metal bar was his, so it was already in the room. It was right there on the dresser. Beside the dresser, I just naturally, she was coming at me with a knife, and it was just natural, almost like it was just natural instinct. I just instinctively grabbed the metal, kind of told her to stop. Well, stop, and then she didn't stop, and metal bar.
The intent to the repeated to Susan's skull after she was already down on the ground with a heavy reflect a clear intent, even if formed the instant before the initial strike, to take her life. At the barest minimum, it was practically certain to result in her death. You've seen the photos of how significant those impacts were. The final element of first-degree intentional homicide the state must prove in this case is that Mr. Pickett did not actually believe the force he used was necessary to prevent his imminent death or great bodily harm. And the state has met this element by proving beyond reasonable doubt again that Mr. Pickett did not actually believe he was in imminent danger at the time these cases occurred. And again, this goes back to the only version of Mr. Pickett's three stories that's really credible. The version supported by the physical evidence is again the recorded confession you heard him give to Mr. Mansavage. There was no claim of self-defense raised at that time because Mr. Pickett never actually believed that he was in any danger at that time. When specifically asked at the interview, "Did she fight you?" Mr. Pickett's response was no. He also told Agent Mansavage that Susan didn't say anything to him while he was in her. And he added, "You know, Chico, he didn't even try to defend my mom." That the attack on his mom was not justified by self-defense is further supported by the three prior occasions of unprovoked physical violence that Mr. Wheeler testified to. There's simply no basis to find that Mr. Pickett believed he was in imminent danger of great bodily harm in this case. Based on the physical facts you've seen and the testimony you've heard, there's nothing that supports anything other than first-degree intentional homicide in this case. For these reasons, when you go back to the jury room to deliberate, you should find him guilty of first-degree intentional homicide. And based on his admissions to Agent Mansavage, you also should find him guilty of mistreatment of an animal resulting in death, as there's no question that intentionally striking the dog with the bar, and it as he said he did, was unprovoked and an unjustifiable cause of death, Chico. So I will ask that you find him guilty of both counts as charged.
Yes, sir.
Has the jury reached a verdict, sir?
We have, Your Honor.
Hand the paperwork to the bailiff, please. You may be seated. The verdicts are two guilty verdicts, a first-degree intentional homicide and a mistreatment of animals. The clerk will officially read the verdicts into the record.
May the jury find the defendant, Shawn R. Pickett, guilty of first-degree intentional homicide as charged in count 1 of the information, dated the 7th day of July, 2022. Second verdict, may the jury find the defendant, Shawn R. Pickett, guilty of mistreatment of animals as charged in count 2 of the information. Did treating the animal in a cruel manner result in the death of the animal? Yes. Dated the 7th day of July, 2022.
Members of the jury, if that is your verdict, please raise your hand. There are 12 hands raised. Attorney Erickson, do you wish any individual polling? No. Does the state wish any individual polling?
No, Your Honor.
Mr. Pickett, individual polling is a process whereby I can ask each juror if that is their verdict. They're not going to explain their reasoning. They just say yes or no. Do you need me to do that, or is it fine that they all raise their hand at once?
If you could individually, that'd be...
Sure.
I would object and waive any argument.
The verdicts are supported by the evidence. I will enter judgments of conviction consistent with the verdicts. We'll set, I presume, a date for sentencing in the future?
Yes, Your Honor. On that subject, I'm taking the bench August 1st. My last day where I'll be in the office here would be likely July 26th.
Is there a request for a pre-sentence investigation report?
Yes.
All right, one will be ordered. That means probably, Attorney Allen, you won't be the prosecutor at the time of sentencing, but that's the way things go. We will set sentencing then about 60 days down the line. I'll have my assistant give me a date. Are you reaching out, Paul? Roughly. Thank you. I'm thinking an hour.
I think that should be adequate, Judge.
Sure.
September 20, September 21 in the afternoon is proposed. Clerk prefers the 21st, which is a Wednesday afternoon.
Mr. Holmes would prefer the 20th if possible. No. Well, the...
Who knows?
That should be fine. I hate to commit someone to it, but we'll certainly have someone in office by then, so I don't think that should be a problem.
Either day, I don't have anything. Whatever works.
All right. Did you say the end of the day, Attorney Erickson?
Either day.
Oh, either day.
Anything works.
She's proposing September 15th, if that would be better for anybody.
I think it, what's that?
September 20, in the afternoon, 3 o'clock.
I'm sorry, Your Honor, which o'clock?
3.
Oh, very good.
Shawn Pickett was sentenced to life in prison without the possibility of parole for the murders of his mother, Susan Pickett, and the family dog, Chico. The court took into account the severity of the crime and the allegations of mental illness. On March 31st, 2022, Dante Tate was involved in a high-speed pursuit that resulted in the death of Bluffton police officer Dominic Francis. The chase started when Tate and 2 other suspects fled from a stolen vehicle in Hancock County. As the charges were presented, Tate faced the sobering reality of his actions, and the gravity of his decisions became painfully apparent.
And we're on the record in 22 CR 0287, State versus Dante Tate. Have a seat, sir. Please. You can all be seated. We're on the record in this case, and I understand we're here today for a change of plea. Mr. Salisbury, are there any amendments to the indictment?
No, Your Honor.
Okay. Mr. Callow, is that your understanding as well?
Yes, Your Honor.
Are we going to be entering pleas today, and then we're setting this out for sentencing
Yes, Your Honor.
in about 4 to 6 weeks? Is that your understanding as well?
Yes, Your Honor.
Okay, good. No problem. I have to talk to you. It's going to take about 5 or 10 minutes. And in the end, I got to decide that you're doing this knowingly, voluntarily, and intelligently. So this is what you want to do. All right? If there's something I say that you don't understand, stop me. And I promise to get the question answered to you. What's your name, sir? Are you a citizen of the United States? Are you represented by Mr. Callow? Did you tell him all the facts and circumstances about the case so he can properly represent you? Have you had enough time to talk to him? What's the highest grade you attended in school? Okay, so what I'm trying to get to is you read and write English, yes? Okay, good. Are you now under the influence of alcohol or drugs today as we sit here? Have you ever been adjudged to be mentally incompetent? Anybody take you to court and say you were so crazy you couldn't handle your own affairs? All right, I'm going to talk to you a little bit about what your rights are, as much as I can explain, and I'm going to ask you how you want to plead, okay? The first charge is a single count of failure to comply with the order or signal of a police officer, fleeing, right? It says that on or about the 31st day of March 2022, and in Medina County, Ohio, you operated a motor vehicle so as to willfully elude or flee a police officer after receiving a visible or audible signal from the police officer to bring your motor vehicle to a stop, and that the operation of the motor vehicle caused a substantial risk of serious physical harm to persons or property. Single count, Felony 3, failure to comply with the order of signal police officer or fleeing. That's a felony of the 3rd degree. The next count alleges on the 31st day of March 2022 and in Medina County, Ohio, you did knowingly receive, retain, or dispose of a car, a 2010 Toyota Prius, the property of another, knowing or having reasonable cause to believe that property was obtained through the commission of a theft offense and that the property is a motor vehicle. This is a count of receiving stolen property, a felony of the 4th degree. Now, the first count, the fleeing, is a felony of the 3rd degree, punishable by a maximum of 36 months in prison. Count number 2, the felony of the 4th degree, is punishable by a maximum of 18 months in prison. If I were to send you to prison for these offenses, because it's a fleeing offense, these sentences must run consecutively or one after another. These are not offenses for which prison is mandatory. I do not have to send you to prison. It's possible. If I were to send you to prison, you'd serve your prison sentence day for day. They've got something called earned prison credit, but you're not guaranteed earned prison credit. If I were to sentence you to prison and you served your time and you were released, the prison authority may place you on post-release control in count number 1 for up to 2 years. And they must place you, for up to 3 years, and they must place you on post-release control for 1 year. On the second count, they may place you on post-release control for up to 2 years. If you were to violate any of these rules and regulations, the prison authority could return you to prison 90 days for every violation, up to half of my total stated prison term, and if you committed a felony offense for up to 2 years on count number 2, and up to 3 years on count number 1. All right, that's all the punishment stuff. Dante, let me tell you what your rights are. You have the right to a speedy and a public trial by jury. At the trial, you'd have the right to have an attorney, and if you could not afford one, I'd appoint one for you. At the trial, you'd have the right to confront the witnesses against you, subpoena your own witnesses, and testify yourself. If you decided not to testify, I'd tell the jury the fact you're not testifying could not be used against you. You have the right to plead not guilty. That's a total denial of the charge. Guilty is a total admission. Not guilty by reason of insanity is just what it sounds like. Those are all the rights you have, and you're giving up those rights because you want to enter a plea to these charges. And so I have to ask, have anybody threatened you in any way to get you to change your plea? Has anybody promised you anything? What I promise you is we're not going to get sentenced today. We're coming back for sentencing in between 4 to 6 weeks. And that at that time, you'll have a chance to talk to me and your attorney will and the state about what the proper sentence should be. Other than that, has anybody promised you anything? Okay, I want to ask you now how on each one of these charges you want to plead. The first one is the fleeing charge, the felony of the 3rd degree. Sir, how would you plead to that charge? Okay, and the next one, sir, is the receiving stolen property charge. How would you plead to that charge? I believe your change of plea was made knowingly, voluntarily, and intelligently, and I'll accept that change of plea. I'm going to make findings of guilty on each, and we're going to come back for sentencing. Terry?
August 8th.
August 8th. We'll see you on that date. Thanks very much. Thanks, Mr. Callow. Thank you. Mr. Dante Tate. Mr. Tate is present with his attorney, Mr. Callow, State of Ohio, by Assistant County Prosecutor T.J. Murray. Here today for sentencing, the defendant was found guilty of 1 count of failure to comply with the order or signal of a police officer, a felony of the 3rd degree, and 1 count of receiving stolen property, a felony of the 4th degree. I'm prepared to go forward with sentencing at this time from the state.
Yeah, thank you, Judge. As the court's probably aware, this case involves from the incident which occurred over in Bluffton, which an officer was struck in a vehicle. Be on the lookout, was put out for that vehicle. Officers in Medina County ended up locating that vehicle on I-71, engaged in a pursuit, which disturbingly, after the incident in Bluffton, the defendant comes here and engages in a pursuit, which got up to 115 miles an hour on I-71. Traffic was at some point stopped up in Strongsville to allow this pursuit to be engaged there. The defendant got off at Route 82 in Strongsville, continued west there, speeds up to 75 miles an hour, ran red lights. It's quite frankly, it's an incredible circumstance that nobody else was injured or killed out of this chase. It ended up being, the only way this was ended was a Crumpler Hills officer actually struck the defendant's vehicle, knocked him off the road into a ditch, at which point the defendant was arrested without incident. It is important, Judge, I think, to note that the defendant doesn't appear to be the one who was driving the vehicle in Bluffton. The officer, however, the actions here after what had occurred over on the left side of the state, it's, I think, certainly a call for us to recommend maximum prison sentence in this case. Be 36 months on count 1, 18 months on count 2 consecutive.
Thanks very much. Mr. Callow, sir.
Thank you, Your Honor. Judge, I'd like to point out that Dante is a 19-year-old young man. When he was interviewed by your probation department judge, I think that he did two things that are very important to point out. One is he admitted his guilt for this offense. He understands when he did wrong. The other thing is he gave you the explanation for his behavior, which after everything that happened earlier that day and the day before, he thought that the police were in his mind fleeing for his life, and in his mind in a very desperate situation, scared, literally scared to death. So he was fleeing for his life. Judge, he has no criminal record, as you know from the review of the report. He has 2 pending cases and no felony record. Judge, I think it's important that we view this case with what's in front of you with these 2 charges. One is a felony from the 3rd degree, the other count is a felony from the 4th degree. Judge, I agree that considering the fact that he has no prior felony convictions, Judge, we would ask that you take that into consideration and consider him on a community control sanction for felony 3 and a felony 4 first convictions, first felony convictions.
Sir, is there anything you'd like to tell me to lessen or mitigate punishment? This is your opportunity to tell me anything you want to say. Sir.
Yes, Your Honor. I take full responsibilities of what I did. I didn't do it because of arrogance for the law. I wasn't the one who shot the officer. And I just didn't know what could have happened there. I was just sat there. I think it's just not so far as what just happened. I'm thinking like the officers in relation to the officer who has been striking. Right? They could have been friends. You know, they've been working with each other for a long time. I thought they would try and kill him. So I ain't just do this just to break the law. I did it to I felt like I was surviving. I was trying to get home to my family. I'm still, it's still not right that the officer was, I ain't do it because he could have saved me on any other day to something that could have been happening to me. I don't really have priors. I stay out the way for real. I should have never been with them people in the first place. They never had nothing going on in their life. I got my own business. I breed charmer bullies.
Say that one more time. I did not hear what you said.
Business.
I got that part.
Oh, I breed tri-mirror bullies and Italian masters, cane corsos. Being a family person. I'm sorry for what happened.
1 year in prison on count number 2, run those concurrently. When you're released from prison, the prison authority may place you on post-release control for up to 3 years, must place you on post-release control for 18 months. If you were to violate those rules and regulations, the prison authority could return you to prison 90 days for every violation, up to half my total stated prison term, and if you committed a felony offense for up to 3 years. Is there a license suspension? The court will order the appropriate license suspension as ordered by law in this particular case. Costs are waived. Good luck. Thank you.
Dante Tate was sentenced to 50 years in prison for the death of Bluffton police officer Dominic Francis. Convicted killer William Johnny Hullett appeared in court, where prosecutors presented a video from a 2001 jailhouse interview.
Take us back to the beginning and tell us how all that information came about.
First, I couldn't see me. I told him I didn't know nothing about the Spain. It's the truth. I said, what you gonna do? Tell me about it. Yeah, bring it up. Let's do it. I didn't know nothing.
All right.
So kept cutting, kept running. Asking me questions I couldn't answer. And hope told me the only way you get your case back in the court now, since you've been due for certain, they dismiss it. So this can help us.
And what do they want you to do to help them?
Well, I made it up.
video that you did, where did you get the information that you spoke about? Okay.
He's scared more to ask me questions, say, did you do electrical work? I said, did it here? I didn't know what you understood. I didn't have it. I read it here in prison.
Okay. How did they get in contact with you in the first place?
Really not nothing. My brother came to me a week before and said that his stepdaughter, I knew what I was becoming, get my case back in the court. And then when he left, he didn't give me no name. And when he left the next week, they were reports, and I called him Brother Bishop, and Diane Hope, Big Skidmore.
That was the first time that you had it.
I think Sterling's paying gave him my name.
Why did you do that?
Well, he did that before in jail. When he was in jail, he went there and they told his lawyer that I told him that I'd done what he was accused of.
Is that the truth? Okay.
I thought he was going to go over and tell me this. It was not tell me.
Okay. Tell me about how Fred's name came up in this.
Fred had a purpose for that before I had started doing Robert Gordon. Robert Gordon got out and I was in Fred and me and Fest and I went to work together. We was always together, work together. I'm telling you today because they tried to put this, turn all this and all this into a movie. I was not to take that out because it's not true. When she said all about getting my case back in the court to help them, she finally figured out how lawyers. She finally figured out the DNA test, and this DNA test would go to California to the same place that OJ Simpson did. DNA. That's great.
He was sentenced to life in prison without the possibility of parole for his crimes. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.